So hello, everyone. I'm Kevin Matz, partner at Aaron Fox Schiff in New York City and the chair of the New York State Bar Association, the State and Gift Tax Committee. I'm delighted to welcome you all to this year's Mortimer H. Hess Memorial Lecture featuring the one and only Todd Angkatavanich. So let me start out with a little bit of history about this lecture series. Since the late 1960s, the Mortimer Hess Lecture has been sponsored annually by the City Bar Association and Gift Tax Committee. The lecture series was originally created by the family of the late Mortimer H. Hess, who is a tax lawyer, and has been made possible through a generous grant by his family and also by his former partners. The subjects of the lectures are related to the law of trust, estates, and taxation, subjects in which Mr. Hess was an acknowledged authority. This year's Mortimer Hess Lecture is to be given by another such acknowledged authority, Todd Angkatavanich. And Todd is a partner at McDermott & Emery in New York City and focuses his practice on advanced wealth and succession transition planning. Todd represents both national and international families and family offices in structuring multi-generational wealth transfer, preservation, and business succession vehicles, with an emphasis on navigating the transfer tax pitfalls that often arise under a subject near and dear to Todd, Chapter 14 in the Internal Revenue Code. Todd's practice often involves structuring vehicles such as sales to grantor trusts, grantor retained annuity trust, GRATs, family limited partnerships, preferred freeze partnerships, as well as vertical and non-vertical approaches to planning with carried interest for private investment vehicles. Now, Todd has published articles in publications such as Trust and Estates, the American College of Trust and Estates Councils, that's ACTEX Law Journal, Estate Planning, Bloomberg Tax Management, Society of Trust and Estate Practitioners, STEP Journal, and other publications. Todd is also the co-author of Bloomberg Tax Management Portfolio number 875, which is titled Wealth Planning with Hedge Funds and Private Equity Fund Interest. A frequent speaker, and that's an understatement. Todd has given presentations for a number of organizations, including the Heckerling Institute on Estate Planning, ACTEC, Notre Dame Tax and Estate Planning Institute, University of Southern California Tax Conference, American Institute of Certified Public Accountants, the New York State Society of CPAs, as well as other estate planning conferences and family office groups. Todd is talking to us today about things to watch out for with sophisticated estate planning techniques. Without further ado, introduce Todd. Please take it away.
Thanks so much, Kevin, for that nice introduction and for inviting me. Kevin and I have been good friends for a long, long time and really appreciate you inviting me here. And I appreciate all of you coming out on a hot July Monday. We'll have some cocktails later, but it's funny, just 2 days ago, I was in Milan with my family on summer vacation, sipping some Aperol spritzes and having risotto and way too many carbs, and now we're shifting to the things that are going to keep you up at night. So it's quite a contrast. But we're going to spend the next hour talking about different things with sophisticated vehicles, right? Kevin and I were talking back and forth about the title for this. One of the other titles was Things That Go Bump and Thump in the Night, right? So what we're going to cover tonight is not new news to anyone, but it's always a really good reminder of, we always hear it's so important to kind of respect the formalities of different transactions. We all know that. Here, it's just going to be a visitation of different techniques and reasons why it's so important, right? Because I think a lot of times we talk to clients about situations, we see that things are in place. We, of course, tell people it's important to respect the formalities. But today we're going to examine why it's just so important to respect these formalities and what can go wrong. Best laid plans sometimes don't go right. So the analogy I like here with a lot of these sophisticated vehicles, it's like a sophisticated car, right? And, sophisticated cars can be very powerful, they can be expensive, but they're often very temperamental. And if you don't properly administer them, if you don't properly maintain them, things can go wrong. And so I think it's so important when we're talking to our clients to make sure that they understand, basically reading the owner's manual so they know how to operate these things properly. It's so typical that we put these fancy vehicles together, we speak to the client about them, and then they're sort of off to the races. But what happens so many times is people kind of get busy with their own lives, right? And they're busy sort of doing the things that made them successful in the first place. And unfortunately, you sometimes have these vehicles that just get put in the drawer. And that's where a lot of these things go wrong, right? And that can happen with GRATs, family limited partnerships, sales to defective grantor trusts, buy-sell agreements, preferred partnerships. And we're going to cover a bunch of those things today. There's a lot of material that we're going to cover. Probably not going to cover all the materials that are in the PowerPoint, but I've kind of tried to include a little bit more in there for your reference. The other thing I would say to our kind of sophisticated sports car analogy is even with the most finely tuned vehicle, there are potholes in the road. And so we're also going to cover a number of those different pothole or pitfall issues, a lot of them under Chapter 14, to just be aware of, okay? So let's get started, okay? Going to mix metaphors here a little bit. One of the ways I like to kind of think about the different kind of estate planning techniques, right? There are the things that are the fairway shots. There are things that are the more aggressive shots. But I think it's so important that when we're talking to our clients that they know what they're getting into. I can't tell you, and I'd be interested in hearing from people too, I can't tell you how many times I've spoken to people and they're saying, okay, well, this is pretty standard, right? This is a fairway shot. Sometimes it's a fairway shot, but how many times have you spoken to clients and they've been planned into something that is like a triple stack aggressive and they think it's a fairway shot, right? And that, you know, I think that lack of communication or lack of understanding can really kind of lead to some problems. So I think really sort of explaining to the client what they're getting is such an important thing. If they want a fairway shot, we can give them that, right? But if they're going to have something that's going to be 185 yards out from the deep rough with a low-hanging branch and a sand trap and a water hazard, okay, it's conceivable you might get it on the green. I know I won't. I have a hard enough time getting it from the fairway. But at least the client should know what they're getting into. If it's a really aggressive shot, they should know that it's a really aggressive shot. Okay, so with that, let's start with sales to defective grantor trusts, something that we probably all are very familiar with and probably implement quite a lot, right? Personally, I think these are incredibly powerful vehicles. We could talk about comparisons between GRATs and sales to grantor trust. They have their relative pros and cons, okay? But I tend to like the sale to the defective grantor trust a little bit more because of your ability to leverage the GST exemption and make that multi-generational. Now, we're not going to talk about the mechanics of the sale to the grantor trust or the GRAT for that matter, but I think it is important that we be aware of some of the challenges that we've seen raised by the IRS with the sale to the defective grantor trust. Now, in my mind, this comes down to different flavors of arguments, right? You've got the more basic argument, which is, look, the promissory note, $100 million promissory note, we don't think that it was a real debt because we don't think that the parties intended from inception to really treat this as true debt, just like a bank loan, right? And so if the factors sort of point to, well, there wasn't really an intention between parent and child or parent and the trust to really treat this as real debt, okay, the argument by the IRS has been, well, because of that, we think that this $100 million promissory note isn't worth the paper that it's been printed on, okay? Now, a number of factors go into that. You know, some of them here are sort of just good things to sort of think about. And the article that I included in the materials covers a lot of these things too, right? But really looking to the record of payments. If payments were late, did parent just kind of say, okay, that's fine? Or did they take actions to enforce and to receive that payment? How were they reported? Were they reported on the books? If it wasn't a sale to a grantor trust, were the interest payments paid? Those are sort of some of the basic arguments that we're seeing from the IRS, and we still continue to see that. An interesting thing, though, the Bolus case from 2020 took it one step farther, in my mind. So in the Bolus case, this involved a number of loans from mom to her son, who was an architect, had a very promising career at the time the loans were made. And then later on, during the life of the note, son's career didn't take off the way they thought it was going to. And so it became apparent during the life of the note that son was not going to be able to comply with the requirements for the payments under the note. And the tax court said, well, at the time that the loan was made, there was a true intention, they were convinced, to treat this as a real loan. And so the court said there wasn't a deemed gift at the time the loan was made. But then somewhere along the way, when it became apparent that son's career was not taken off and he was not going to be able to service the debt, and mom changed her estate plan accordingly, the court said at that point that sort of evolved into a deemed gift. And so I think that's an important thing to keep in mind. Other types of attacks on, this is not, Paul, the clicker is not advancing? There we go. So in addition to sort of the base challenge of the note, there are additional challenges that the IRS has made to the promissory note transaction, more technical challenges under Section 2701 and 2702. So in the Karmazin matter, from about 10 years plus, bless you, there was a sale of family limited partnership interest into a grantor trust in exchange for a note. Okay? The IRS's argument was that the promissory note was not real debt because of a number of factors, but rather it was a disguised equity. And they said it was a disguised equity that was a different equity class. And therefore, the IRS's argument was that this was basically violative of Section 2701. We'll talk about that a little bit later more, but Section 2701 can be triggered with big deemed gift consequences if you make a transfer essentially of one class of interest, a subordinate class, to the kids or a trust for the kids, and you take back a senior equity class. The IRS's argument here was that the promissory note was essentially a disguised senior equity class of interest, and because it was a senior equity class that didn't satisfy the requirements of 2701 as a qualified payment right, they said that 2701 would give value to mom in this case, not of the full value of the note, but rather zero. So that's another flavor of sort of more technical challenge on this. Similar argument that was also raised in Karmazin, and then more recently was raised in the Welbing case, is similar to the 2701 argument in that it's a recharacterization, but it was under 2702. And in Karmazin and Welbing, the IRS said, well, the sale of the asset into the trust, taking back a promissory note, was really a disguised transfer in trust, right? And so if you make a transfer in trust with a retained interest, unless you satisfy 2702 and have a qualified interest, basically a GRAT, okay, your retained interest is going to be valued at zero for gift tax purposes. So in Welbing and Karmazin, the IRS said that the sale of the asset to the trust, the sale of the partnership interest to the trust, taking back a promissory note was a transfer in trust, and the promissory note was not recognized as real debt, but rather as a disguised retained interest in trust. And because that promissory note did not satisfy the requirements of 2702 as a qualified interest, the IRS's argument was that that resulted in a deemed gift of the entire amount of the transfer into the trust without any credit received for the value of the note. So interestingly, you've got these three theories, right? One, that the debt is basically bogus because there wasn't an intention of the parties to treat it as real debt. And then you have disguised equity, second class under 2701, and then you have disguised transfer and trust with a retained interest under 2702. The net result, however you get there, these three avenues, the net result is the same argument that I put $100 million, I sold $100 million into this trust, and my note was worth zero, either under traditional argument purposes or under 2701 or under 2702. So I think as we're doing our sales to grantor trusts, some takeaways from these is you really want to make sure you can do everything you can to really sort of support that this note is a real debt and that it's not illusory, and that hopefully should prevent you from having recharacterization as disguised equity or disguised transfer with a retained interest. Interestingly, in the Welbing case, in addition to the gift tax arguments, and the Wolben case was the Carmex lip balm company family, where they sold assets, they sold shares into the trust, took back the promissory note, right? On the gift tax side, the IRS raised 2702, but they also raised, because this was an estate tax case also, they also raised that the promissory note was really a disguised transfer with a retained interest for 2036 estate tax inclusion purposes, right? And there wasn't a lot of development in the pleadings, but nonetheless, it's important to know that this is an argument that's out there, and they've been starting to sort of raise that, okay? And this goes back to some of the older cases, particularly the Fidelity Philadelphia Trust case from way back when. And, in that case, the court laid out a number of factors that you really need to kind of take into consideration so that you're going to give yourself the best position to not have that note be recharacterized as a retained interest. And I think the third factor here is probably the most important in my mind, is that if you're going to make your sale of assets into the trust and take back a promissory note, you really want to try to be careful to ensure that you're not just matching your payments under the note to the amount of income that's going to be generated or anticipated to be generated off of those assets that are sold. Okay, so all of these are sort of under the umbrella of kind of things that go bump and thump in the night with respect to the sale to the Defective Grantor Trust. Obviously, we have the valuation issues as well, right? Is the sale for adequate and full consideration, that kind of thing. I'm not going to touch upon that as much today, right, and how you can try to address that with formula clauses or price adjustment clauses, but these are really kind of going to the administration of the note. The more strictly you can administer the note, the better chance that you have against a recharacterization argument. So let's talk about FLPs a little bit. If I can get a show of hands, how many people here deal with and implement family limited partnerships? Okay, so pretty much all of us, right? Now, what's interesting, and I'm going to be dating myself here, but when I first started practicing law, the estate tax exemption was $600,000. And I remember going to some seminar, and there was some person talking about these things, and it was very sort of flip, just actually no pun intended there, but I guess it is a pun. But it was just very cavalier. Oh, just throw it against the wall, see what happens. And I remember the person was saying, oh, not only can you sort of keep a string, but parent can keep an actual rope, right? And it just seemed so, I don't know, didn't seem quite right, right? And this was 10 years before the Strange case came along. But the way it was often kind of presented, it seemed to me at least, it was often presented like, what do you have to lose? Throw the assets into the flip wrapper, and what's the worst that can happen is that you don't get the discount. But it was often said, well, mom and dad are both U.S. citizens, so who cares, because you'll have the marital deduction apply, and no harm, no foul. I think the way that the cases have evolved since then, though, really sort of challenge that assumption, and I think it shows that assumption is just not right. But here's our basic example. We've got the $100 million in the family partnership. Maybe mom or dad has transferred by gift and sale, let's say 50% of it. And so when parent dies, they own 50% of the FLP. The other 50 has long been transferred into the trust or to the kids. The understanding or the expectation by everyone is, okay, 50% of this is included in parent's estate. The whole thing's worth $100 million, and maybe we have $50 million. Let's just do away with discounts for this example. And so at a 40% rate, you have a $20 million estate tax, right? Now, we all know if 2036 comes into the picture, like it has been, we've got $100 million included in the estate, or maybe $150 million if it's appreciated, right? And so our estate tax liability is going to be much higher, maybe $40 million in this example, assuming that the whole thing is worth 100. But it actually could be quite worse than that, potentially, right? Because now what happens, right? You could have a potential marital deduction mismatch. And what does that mean? And Kevin has spoken about this and written about this quite a bit, but it's really quite a whipsaw. And it doesn't seem intuitive, so I go back to 25 years ago when I was hearing about some of these descriptions of this, and it just seems so simple and cavalier. Okay, mom and dad are both U.S. citizens, so no estate tax until both spouses die. But the marital deduction mismatch, that was raised in the Black case, in the Schertz case, and more recently in the Turner case. And it's been raised in other non-FLP cases, DeSanto and some of these other ones. But the basic notion is, well, okay, in our $100 million example here, now we've got $100 million that's included in the gross estate under 2036, A1 or A2 or maybe a combination of both, right? So now we've got $100 million in the gross estate, but what do we have in the probate estate that's available to pass, let's say, into the Q-tip trust? The most we have is $50 million that can go into the Q-tip trust and get the marital deduction. And if you look at the position that the IRS raised in the Black case and the Schertz case, they tried to say that that $50 million here should be discounted because it's not a voting interest. So let's say you've got $50 million as your maximum that's available to go to the Q-tip trust and get the marital deduction. Well, you've got $100 million included in the gross estate, and so now you've got $50 million that's subject to a first death estate tax. Now you have a first death estate tax paid, and every dollar that gets paid to the IRS is not going to qualify for the marital deduction. So that triggers its own estate tax. And then you can get into a circular tax on tax on tax. This is something that the court looked at in the Turner 2 and the Turner 3 case. Luckily, in those cases, okay, there was a reimbursement provision because the court was really, I think, trying to search for, kind of some sympathetic result for the taxpayer or for the estate, and they were able to say that there wasn't a waiver of a right of reimbursement. But this is something that's a really unexpected whipsaw out there, and I think given all the developments on 2036A1 and more recently on 2036A2, it's a really important thing for us to stress test our partnerships right now to get a real sober understanding or a good sober look at it right now while your clients are healthy, rather than waiting until you have some sort of triggering event. So there's a lot to the 2036 analysis. I'm not going to go into all of it given the time frame, but there are more slides in here that go into the detail. But this is one slide that I've developed this just as a way to sort of conceptualize the analysis. I think we often hear that, well, this partnership seems okay, it feels okay, right? And it should be okay. But I think, when you read through the cases, it's a very methodical analysis that the tax court goes through. And I think just a feel test or a smell test really isn't going to do the trick. And so what I've tried to do here is just kind of establish some sort of, conceptualization for how to do the analysis. If you go through the cases, and Steve Akers talks about this quite a bit, that in the cases under 2036 where the estate has been victorious in an FLP challenge, probably 95% of the time the estate has been victorious by winning on the bona fide sale exception, right? And there's maybe one case or maybe two cases where the estate has lost on the bona fide sale exception argument, and then nonetheless went ahead and were victorious in establishing that there wasn't a 2036 A1 or A2 string. Okay, so the reason, if you kind of look at this as a playing field analogy, the reason why the biggest part of the field, the blue part, is kind of occupying about 80% of this field, that's just to signify that the name of the game really appears to be the bona fide sale exception for the most part in this analysis. And that's the first part that the court goes to in the analysis, with the exception of a couple cases. And so the tax court has basically said, in order to establish that the bona fide sale exception to 2036 was satisfied with respect to the initial capitalization of the partnership, when mom and dad or mom or dad put whatever, the $100 million into the FLP, the court needs to be satisfied that the rationale for doing that it was in furtherance of a legitimate and significant non-tax purpose, right? Seems simple enough, but the problem with this, or the challenge with this, is it's not like a day count, right? We can't determine this with absolute certainty. The best we can do is sort of build up our argument, and as we're assessing our partnerships now, really try to look at it like a health test or a stress test to see how sort of convincing your argument is. And what the court has made clear in these cases is that they're really looking not for the theoretical justification, but rather they're really trying to get to sort of the essence of, the reasons for the creation of the partnership. Of course, they know that there are some tax advantages to it, but it can't just be tax advantages alone. There's a couple cases that I like. The Bondguard case is a good example of a double-edged sword, because in Bondguard you had contribution of closely held stock into an LLC for the purported reasons of creating an entity that could be used to go and raise third-party capital. But then they took the LLC interests and they put them into an FLP for purported reasons of asset protection and management. And so on a 2036 challenge, the court said, well, okay, look, the first contribution of the stock into the LLC in order to create a platform to raise third-party capital, that makes sense. We're going to say that that satisfied the bona fide sale exception. But then the second contribution of those LLC interests into the FLP, they said, well, all these things that you're saying were the reasons for creation of the FLP, asset protection, succession, management, you already accomplished that on the first one. So they said that did not satisfy the bona fide sale exception. There's one other case that I like. It's the Halliday case. Different example, much different example. Mom put her securities into a partnership, to a family partnership. She moved into a nursing home, like a week later. Mom died, and on the 2036 challenge, the bona fide sale exception argument by the estate was, well, Mom was concerned about tort creditors, and she wanted to put the assets into the partnership for protection from them. And the court's like, okay, that might be a valid reason. We're not saying yes or no as a general proposition, but tell me this, what kind of tort creditors is Mom going to have when she's living full-time in a nursing home, right? And so what the court's really looking at, and I think this is useful when you're doing your analysis of your different partnerships now and your bona fide sale exception, is matching the circumstances to what's in your file and the documentation. Again, the court has said they're not looking for the after-the-fact theoretical justification for the creation of the partnership. Now, moving along here, right, so back to our playing field analogy, if the estate wins on the bona fide sale exception, then they go to the left, right? The estate wins. There's no further analysis on 2036A1 or A2. If the estate loses on the bona fide sale exception argument, that doesn't mean that they lose. Rather, it means now you have to go to 2036A1 to see if there are any of those classic bad facts that we have all read about over the years, or if there's any control under 2036A2. And we know from these cases, Strange and Powell and the other cases, that it doesn't have to be actual control. It can be control alone or in conjunction with others. So it could just be a sliver of control. And I like to refer to A1 and A2, break it down into the first application and the second application. First application, in my view, of 2036A2 is the more Strange type control, where dad owned 47% of the general partner, that allowed him, in conjunction with his kids, who are the owners of the other interests in the general partner, to control distributions. Right? But then the Strange court went one step further, and then the Powell court basically followed that, which is to say, in addition, even if you don't have any of the general partner interest, mom or dad, the fact that you as a limited partner could cast a vote to liquidate the partnership, not compel liquidation, merely cast your vote yea or nay, that's also a right to sort of get together in conjunction with other people and determine distributions and get back your assets. So if you lose on any of those, then the IRS wins and you lose the 2036 challenge. And so it's a very methodical kind of thing that you need to go through when you're doing this analysis. There's a bunch of other things in the slides that I would kind of leave for you to think about. The one thing I would say, though, is, as you are evaluating your partnership, you want to evaluate it from a 2036A2 standpoint. Is parent in there as a manager? Are they in there owning some of the general partner interest? The second level of that, do they have other interests, even if they're not the general partner or the manager? that gives them the right to cast a vote. And if you have those, aside from whether you have 2036A1 bad facts, what can you do to restructure, right? And so there are things that you can think about to rid parent of those tainted interests. I would caution you before you do that, though, to give a really honest, sober assessment of whether you have the classic bad facts under 2036A1. Because keep in mind, you only need A1 or A2 to bring it back into the estate. So what you don't want to do is go through this whole sort of process of decontrolling mom or dad, and, turns out that you still have all these 2036A1 bad facts, so you're still going to have inclusion in the gross estate. Now, if you've concluded that there's not the types of 2036A1 bad facts that could infect the partnership, and that you primarily want to concentrate on decontrolling for 2036A2 purposes, be really careful when you're in the process of doing that decontrolling to not trigger a deemed gift under 2704A, which can cause a deemed gift by virtue of a lapse, or basically a disappearance of a voting right or a liquidation right. Okay, so let's get away from family limited partnerships. There's some do's and don'ts here. It's not an exhaustive list, but just things to think about. I'm sure there's many more that you could add to that. If there's any comments or questions, feel free to just chime in whenever you like. So, we talked about sales to grantor trusts, we talked about FLPs. Let's talk a little bit about some of the challenges with GRATs. As we all know, GRATs are fantastic vehicles for essentially transferring out the future appreciation gift tax-free by taking back an annuity stream that's worth exactly or almost exactly what we put into it. Put $100 million into the GRAT, take back an annuity stream that's worth $100 million over X term of years, and if we survive that term of years, then the assets are outside of the estate, probably into a GST non-exempt trust. You can't leverage the GST exemption generally unless you're doing some other kind of creative things, but very powerful vehicles. And, we often hear in the comparison of sale to grantor trust versus GRAT that maybe the GRAT is considered more conservative by certain practitioners because it is statutory in nature, and importantly because it has that self-adjusting feature, so that if I put assets in and I value them at $100 million and I take back an annuity that's worth almost $100 million, and that $100 million of assets is revalued to $110, under the regs, my annuity should increase so that the present value of my annuity stream is almost equal to the $110 million revalue, and you should still have a zero gift. And so because of that protection versus some of the uncertainties with the sale to the grantor trust and the valuation uncertainties, it's often looked at as a more conservative vehicle. And I agree with that to a certain extent. The CCA from 2021, as well as the recent Batty case that was recently settled, to me provides a little bit of a, well, not so fast, just understand that there are some reasonable limits to some of the safety features that are associated with the GRAT. And I think it comes down to sort of, pigs get fat, hogs get slaughtered. And in this case, you had a really bad set of circumstances, right? You had, gifts were made of shares of a company into a GRAT. 5 days or 3 days before the GRAT gifts were made, there were 5 offers on the table. There were pre-merger discussions going on before doing the GRAT. And then on the gift tax return, they relied upon a 7-month-old prior appraisal that was obtained for 409A purposes. And that appraisal, happened before there were merger negotiations and certainly before there was an offer. At the same time, gifts were made, charitable gifts were made, and a full fair market value appraisal was used to justify a higher charitable deduction, right? So not the best facts in the world. The IRS looked at this, and in this CCA, they said, well, that the appraisal didn't reflect the factors that would need to be taken into consideration for fair market value, right? A known buyer and seller would be aware of the merger negotiations. And so, the IRS was certainly very offended by this, and they basically said that this amounted to an operational failure of the GRAT. and therefore they said that the GRAT didn't satisfy the requirements of Section 2702, and so that the dollars that you put into the GRAT, let's say $100 million, for instance, did not satisfy the requirements of a qualified interest under 2702, and so you didn't get back under the subtraction method $100 million annuity interest, rather you got back zero. So in other words, the whole darn thing was a taxable gift. Interesting, the IRS cited to the Atkinson case, which was a charitable remainder trust case, right, for the operational failure analysis. And what was interesting is, when you think about GRAT administration, right, a lot of times, going back to what we were talking about before, you provide your care and maintenance memo to the client. You trust that the client and the trustees are going to be able to make those payments on time and sort of comply with all the requirements under 2702. And, to the point that 2702 or GRATs are a more conservative vehicle, I agree with that because it's statutory, but because it's statutory, it has sharper edges than perhaps the sale to the defective grantor trust. If you don't make your payment on time with a sale to the defective grantor trust, that's not a good thing. It's not a good fact, obviously, but it's not sort of the sharp kind of edge or as sharp an edge that you might have with violation of some of the GRAT requirements. Up until this CCA, it was debatable, to some at least, whether if you kind of, if you missed one of the requirements of a GRAT, let's say you made your payment on day 106, for instance, not within the grace period, whether that would blow up the GRAT from inception, right? And people would cite to the Atkinson case, but there wasn't something that was directly on point with respect to a GRAT. Now here, for the first time, as I know, this is tying in sort of the operational requirements of the GRAT to the rationale of the Atkinson case. Also, interestingly, the self-adjustment feature did not come into play here at all. So keep in mind, yeah.
What weight would a...
That's right. But this is just, at least the way I view this, we're looking at the different arguments that they're raising out there, right? So like in the Carmazin case, they raised those arguments under Chapter 14. So this doesn't have weight in my mind, right? But at least it is an important thing to think about how they are crafting these arguments and, the consequence of at least the argument that they're going to raise if you violate the administration of your GRAT, right? What's the argument going to be? That's an operational failure. The Batty case is a similar case, except they went a slightly different direction. They didn't say that, Batty had similar facts, right? Pre-gift merger negotiations, gifts made, and, the assets were revalued by the IRS. And instead of saying, well, this violated 2702, so the entire thing was a gift, rather they said, well, this violated this, and therefore the self-adjustment provisions in the regs were not applicable, and so that you had a difference in the increase in the gift amount rather than increase in the amount of the annuity to allow you a zero gift. So these, to me, you look at the FLP, you look at the sale to the grantor trust, you look at the GRAT, all of this to me sort of points to just the importance of the ongoing care and maintenance and the administration of these vehicles. I think it's just an important thing when we're talking about these things to kind of to look underneath the hood and think about sort of the soft underbelly issues, particularly when we're talking to our clients about it. So I want to talk about Chapter 14 a little bit here. Why do I have some Harry Potter-inspired pictures on here? The way I often like to conceptualize this is that if you take the City of London, right? The City of London is kind of our general estate planning, what we want to do. Family limited partnership, gift, sale to a trust, all good stuff, right? But then there's this kind of ether on top, which is the Chapter 14 ether that lies on top, where you have these kind of rules that don't really make intuitive sense, right? So just like with Hogwarts, you've got, stairs that move as you're going up them. You've got the rules of gravity not applying. And maybe to take this analysis a little further, or this analogy a little further, maybe there was a rationale way back when, for doing some of these things. But they get so sort of twisted. And that's kind of a way that I like to think about Chapter 14, where you can take sort of your base kind of planning intention, and then you've got these kind of rules that lay on top that don't really make intuitive sense, but they can really kind of do a whipsaw on you. And Kevin and I are going to be talking about this at Heckling in January, and we'll kind of go into a lot deeper dive. But here's just sort of a big picture overview of different places where some of these Chapter 14 potholes or pitfalls can come into your practice. Preferred partnerships or LLCs, right? Remember, I was talking about Karmazin before, right, where the IRS basically argued that your promissory note was a disguised second class of equity, and because that second class of disguised equity didn't satisfy 2701, you resulted in a deemed gift. Well, preferred partnership is something that is that second class of equity, but if you're going to do it today, you need to make sure that that preferred and common equity structure satisfies Chapter 14, 2701 in particular. Family limited partnerships, just went through all that, right? We've seen arguments under 2703 with family partnerships, 2704B, 2704A issues. Capital contributions and recapitalizations can bring into play 2701 deemed gift issues. Buy-sell agreements and shareholders agreements, those can have some real whipsaw revaluation consequences under 2703. And keep in mind that if something is revalued for 2703 purposes, for estate or gift tax purposes, it doesn't really impact at all the contractual rights. So you can have a mismatch between the value for estate tax purposes and for contract law purposes. When I first started practicing law a long time ago, I was on an audit where there was a buy-sell agreement, sweetheart deal between, parent and child. There were other children involved, and they weren't happy about the sweetheart deal. And we were in court on this, and the IRS was involved. The IRS was saying 2703 should apply, and so we think that the value should be $10 million. You had the one child saying the contract price was $1 million, and, you ended up with a real whipsaw because the court enforced the $1 million buyout price, and the IRS is saying that's not our issue. We couldn't care less what the buyout price is for contract law purposes. What we're saying, however, is that the value for estate tax purposes is $10 million. So you can have a real mismatch there. Carried interest estate planning, which we'll get into in a little bit. Family office profits interest, the so-called lender structures that we sometimes get involved with. 162 trade or business, kind of structure. But if you have the family office with the profits interest going down to the next generation, that introduces some potential issues under 2701, perhaps. GRATs, QPERTs, sales to grantor trusts, SPACs. So there's a bunch of places that this can sort of come into play. Big picture overview, Chapter 14 takes two broad approaches in their attacking the perceived abuses with family entities and family transactions. There are deemed gift provisions under Section 2701 and 2702 and Section 2704A, which can cause a deemed gift if you have a lapse of a liquidation right or a lapse of a voting right. Then there's a different approach under 2703 and 2704B, which is basically a disregarding approach, which says, look, we are going to disregard the value established for transfer tax purposes under these different provisions. Now, there are four sections to Chapter 14, 2701, 02, 03, 04, right? But this picture here is designed to sort of illustrate the breadth of these, right? You got 2701 there, applies to preferred partnerships, profits interest, note recharacterization, carried interest, vertical and non-vertical slice planning. 2702, GRATs, QPERTs, sales to grantor trusts. So there are different sort of spokes to this wheel, if you will. Okay, so in the time that's left, I want to just talk about some other sort of proactive ideas. So we talked about preferred partnerships a little bit. I talked about how in Karmazin the IRS was trying to say, well, your promissory note was really a disguised class of preferred equity, and therefore it blew up 2701 and was valued at 0. Okay. Well, you can still do a preferred and common vehicle today. You need to make sure that it complies, that the preferred interest complies with Section 2701 in order to avoid a big potential deemed gift. Now, how do you do that? Your preferred interest is generally going to be structured in a way that complies with 2701. And essentially, that preferred interest needs to be mandatory and quantifiable and annual, right? So the notion being that, like a GRAT, we know what we're going to get, we know when we're going to get it, we know how much we're going to get, and so we should get full credit for that and not have a big deemed gift under 2701. Now, here is a basic illustration of it, right? Parent puts in assets into a preferred partnership, capital contribution. They take back a preferred interest that's going to give them the cash flow that they need, the priority cash flow, right? And it's going to match kind of their investment horizon, their sort of risk tolerance, their need for cash flow. And maybe the child or the trust is going to take back the riskier investment in the form of the common growth interest, right? But the reward for that investment is that they get all the upside potential above what the cash flow preferred interest is. And so here's your basic example, and it can be quite powerful. But think about some of the other applications that you can use. We do these quite a bit, right? So while the basic example is parent is the red bucket, the bucket that you kind of don't want to sort of fill up, right? But there are other kinds of red buckets that could be used for these applications. Parent, obviously. What about a perpetuities limited trust, right? We often deal with trusts that only have 50 years left or so, and you've got several $100 million in there. Is there a way that we can kind of plan in advance to shift over and contain the growth in that shorter-term trust? Maybe a GRAT remainder trust, right? In the absence of doing some kind of other fancy, sophisticated planning, most GRAT remainder trusts are going to be GST non-exempt. And while they are great vehicles to transfer value from Generation 1 to Generation 2, when it goes into the GST non-exempt trust at the end of the GRAT for the benefit of the G2 beneficiary, that is soft money, right? Because when the G2 beneficiary dies, that's going to be subject to either a state tax or a GST tax. Maybe a Q-tip trust, right? Going to be subject to inclusion under 2044 at the surviving spouse's death. Maybe a C Corp. Maybe a foreign non-grantor trust. Different types of things that you can think about, but these are all generally less efficient vehicles that if you had a choice, if you can figure out a way to sort of contain the growth in that less efficient red bucket vehicle and shift over the growth into a more efficient green bucket vehicle, let's say, for example, a GST-exempt dynasty trust, it provides for a nice application, right? And so maybe you can take some of these trusts and you make a capital contribution into a preferred partnership. Maybe your funded dynasty GST-exempt trust makes a capital contribution and takes back the common growth interest. And over time, you can shift that growth into the GST-exempt vehicle while providing cash flow to the red bucket vehicle, and then that cash flow can be used for purposes of making distributions out to the current beneficiaries. Now, there are very powerful applications with this. I said before, the big distinction is that if you do one of these partnerships, it needs to comply with 2701, which is basically a qualified payment right. So it needs to be cumulative, payable at least annually, and at a fixed rate. And, the rationale for that is similar to a GRAT, right? A GRAT is really a statutory exception to a draconian rule under 2702 that says I can't put assets into a trust and take back just a pure income interest, right? That's going to be a taxable gift. But a GRAT says, okay, if I create my interest so that it's mandatory, quantifiable, and annual in the form of a GRAT, I'm going to get full credit for that for 2702 purposes. Pardon me. Just one final note on preferred partnerships before we move on. If you are doing a transaction that's not going to be grantor and grantor trust or grantor trust to grantor trust, there are some very thorny partnership tax issues that have to be coordinated. So let's say you're doing it two individuals, or an individual and a non-grantor trust, or two non-grantor trusts. Okay, obviously we have to think about 721B, the diversification requirements. Interestingly, the disguised sale rules under 707 provide a real challenge when you're creating a preferred partnership. And there's a safe harbor under 707 that provides that if you have a reasonable payment in the form of your preferred payment or your preferred coupon, that's not going to trigger gain as a disguised sale. Okay, but there's a real intersection that needs to be coordinated between the safe harbor for 707 and the 2701 rules for a qualified payment right. The other thing, and I think reasonable minds will differ on this, but if you're doing a preferred partnership, you're taking back your preferred interest. I personally think that you really want to kind of do some of your best practices that you would do with an FLP in order to really establish the rationale for creating the partnership and for parent taking back that preferred interest. I mean, really, at the end of the day, you're making a decision up front to divide the economics of your entity between more secure cash flow interests, right, less risky, and you're giving up the upside growth potential in the form of the common interest. Okay, so in the time that we have left, Kevin, what time do we have until? 7:05, okay. Okay, so any questions or any comments before I go to the last part? Okay, so, yeah. It's a great question, and we are generally in a higher coupon environment right now. Rev ruling 83-120 sets forth kind of the cocktail recipe, if you will, for determining the adequacy of the coupon. Just keep in mind, if you do a preferred partnership, it needs to comply with 2701, usually with a qualified payment right, in order to ensure that you don't have what I'll call the big gift tax blow up, which is, okay, the whole preferred or a big portion of it is worth zero. But even if you have a qualified payment right, 2701 compliant, that doesn't mean that all gift tax issues are off the table, to Bruce's point, right? So, you know, if I put $100 million in for my preferred interest, and, you know, the return needs to be calculated to be, let's say, 7.5%, and the partnership agreement says that I have a 4% coupon, okay, it might be a qualified payment right under 2701, but I still have a deemed gift to the extent of the shortfall. So Rev ruling 83-120 says, okay, you start with publicly traded high-grade preferreds as your starting point. But then you've got to risk adjust it, to your point, right, because to reflect the fact that this is a private investment partnership, there's going to be a lot more risk to that, right? Now, you have different sort of levers that can influence how high or low that adjustment goes. The most important one in my mind is how much you capitalize it. So for instance, if partnership A is 90% preferred, 10% common, versus partnership B, which is 50% common, 50% preferred, right? Partnership A that has 90% common preferred, that's going to be a much riskier investment for the preferred holder, right? Because you got to get a preferred coupon on $90 million out of 100 versus a preferred interest on the 50-50 partnership of only, you know, preferred interest of only 50 on $50 million of preferred capital. So there's different ways that you can sort of influence how high or how low it goes. But to your point, you know, the starting point is much higher now because your preferreds are higher now. So right now, one of the interesting applications is the so-called reverse preferred, where if instead of me as the senior family member taking back the preferred interest, I take back the common growth interest. I see the grin on your face there. I take back the common growth interest and I give the preferred interest to, let's say, my kids or my dynasty trust for my kids, right? And if it's a riskier investment because, let's say, my preferred occupies a big portion of the capitalization, now the return required under 83-120 is going to be much higher. And so over time, that might be given a nice bigger return to the GST exempt trust. Now, there are some other ways that you can try to structure things depending upon the valuation of things that go in. But yes, it's a very important point, and we are in a high coupon environment right now. So, that coupon's going to be much, much higher than, let's say, your sale to the Grantor Trust or your GRAT. Okay, a couple more minutes left. Let's get into carried interest estate planning a little bit, so-called vertical slice. We're not going to talk about some of the non-vertical slice issues today, but basically, when we are doing planning, hedge fund, private equity fund interest, I think it's safe to say we're sort of hard-pressed to get in a discussion of estate planning with these fund interests without hearing the term vertical slice uttered, right? It's become kind of synonymous, right? Jay, I think you were probably one of the first ones that was talking about that phrase, right? Like years ago, right? But here, just to conceptualize, here's a generic fund structure where we've got the principal up top is the client. They've got an interest in the general partner that has a profits interest in the underlying fund. The dotted line there, the client usually also has to have some interest in the fund itself. Sometimes that's through the general partner, sometimes that they can show to their investors that they have some skin in the game. At the same time, you often have the principal owning, a piece of the management company that gets typically, let's say, a 2% fee of the assets under management. Now, if we had our druthers, we'd say, well, we want to transfer out the asset that's going to have the most appreciation potential. Well, with the GP here, they get a 20% carry, but maybe they only put 1% capital interest in, and so that's a really good return on your investment. So if we had our druthers, we would just give away or gift and sell away the GP interest of the carry that has the most appreciation potential, right? But now we get into potential issues under Section 2701, right? 2701, the origin of that had to do with preferred and common abusive partnerships. It had nothing to do with carried interest transfer planning, okay? But, Congress basically responded to a perceived abuse with pre-1990 preferred partnerships with a really broad statute. And because of the really broad statute, it potentially pulls into the situation, your fund situation. Now, with a hedge fund, it's a little bit more of a gray area. Arguments could be made that maybe 2701 shouldn't apply. With a private equity, it's a much harder argument to make, in my view, because you do have a waterfall. You have a preferred interest, and then you have a subordinate interest. You have a profits interest. But so I think, it's safe to say that I'd say still probably 90% of the time, 80% of the time, the planning that we see with carried interest transfer planning is the so-called vertical slice. And the vertical slice essentially is going to say, okay, if I'm going to give away 10% of my interest in the GP with the carry, I also need to give away a 10% interest, let's say in my capital interest, in the form of the limited partner. I have a question mark here with management company because it's not clear, right? Because 2701 only applies with respect to transfers of equity interest in the fund here. And it's not clear whether management company needs to be included in that. My personal view is if it's management company and a hedge fund, that's not equity. That's not, it's not an equity interest in the underlying fund, and you shouldn't need to include it in there. In the case of a private equity fund, I think it's a little bit more of a gray area, but I think, I've gotten to a comfort level that, in certain circumstances, you shouldn't have to include management company. But what I would say is there are a number of other issues that come into play aside from the Chapter 14, 2701 vertical slice issues. You have to think about estate tax inclusion issues. You have to think about valuation issues. You have to think about incomplete gift issues. So there's a number of different issues that you need to coordinate when you're doing this planning. And I think that is pretty much the last thing I guess I'll leave you with. Sometimes we hear people saying, well, it's a new fund, it's speculative, and so therefore isn't my carry worth zero? And shouldn't we just make a gift value it at zero and be done with it. And reasonable minds can differ. I'll just note that IRS Attorney Clifford Warren at the USC Tax Institute about 2 years ago was asked this question about the IRS's view of the carrier being worth zero. And he said, look, I get that, people said, well, Rev Proc 93-27, income tax provision says that the granting of a profits interest is not an income tax event. And so he said, I get how that sort of morphed into, okay, if it's not taxed now for income tax purposes, then maybe that means that the carrier is worth zero for gift tax purposes. Suffice it to say, he said, we don't agree with that view. And, if you have a carry that's just been granted in a private equity fund, an established private equity fund, that thing could be worth tens of millions of dollars. And if you're going to take that view, quote, that's a fight we would love to take. So with that, I'm going to leave you guys to think about the things that go bump and thump in the night. And thank you very much for coming out on a Monday evening.